Good morning. Oh, great. Now we're off to a good start. Okay, on behalf of myself, Judge Borello, who's going to be joining us listening in on Zoom today, and Judge Rick, welcome to the first day of our Grand Rapids case call. I can assure you that we have been diligently working on these cases for the past month. We've had the benefit of your briefing, as well as the work of our research division and our chambers. Trust me when I say we are familiar with the relevant facts. And if you don't believe me, I mean, here it is, okay? So we're familiar and with the law. So I would ask if you could please focus on your salient points, or if you have new authority to bring to our attention, we're happy to hear that. Just a few rules for those of you who are new to the court today. If both sides are endorsed, you have 30 minutes, please. It's not a goal. I think the point of oral argument is to clarify and help us reach the result that you want to reach in your case. If you are the only one endorsed, you have 15 minutes. I'm happy to help you keep time. And for those of you who are appellants, to save you a few minutes for rebuttal if you ask me first. I'm happy to do that for you. Today, we're also hearing some matters involving sexual assault victims and children. Because our proceedings are recorded and can be viewed by others, please substitute initials in lieu of using a sexual assault victim's or a minor's full name. Okay, with that, we're looking forward to hearing your arguments, and we're going to begin by calling item number 1, docket number 366-517, People of the State of Michigan versus Julie Ann Zimmerman.
Good morning, Your Honors.
Good morning.
May it please the court. My name is Garrett Burton. I'm from the State Appellate Defender. I represent Ms. Zimmerman, who is joining us in the courtroom today.
Okay.
As you know, I raised 3 issues in my brief, and I'd like to take the first 2 together, the sufficiency argument and the ineffective assistance of counsel argument, and then I'll end by talking about the other act's evidence. So, Your Honors, as you know, Ms. Zimmerman was charged with committing perjury for 2 reasons. The first was saying allegedly that she didn't have her phone at the time horses were seized during a civil forfeiture hearing.
Right.
And the second was she said she wasn't aware that animal control was on her property till she went out and talked to the deputies.
And actually, it started with 3, correct? And 1 was a directed verdict.
Yes.
Okay.
Yeah.
So, yeah.
On a separate count.
Yes.
And so the transcript makes it clear that she was not lying during that civil forfeiture hearing. So I appended it to my briefing, and you'll see that on page 69 of that transcript, she says that she had her telephone for the first 10 or 15 minutes.
Right. You want us to take judicial notice of that?
Yes, Your Honor. I would like that. I also move for remand if you want to have a proceeding like that. But I think given that it's a certified transcript of a civil forfeiture hearing, you can take judicial notice of it.
Yeah, I mean, we are familiar that, well, you quoted these parts of that transcript.
Yeah.
And I mean, the reality is she walked out of the house with that phone in her hand.
Mhm.
So clearly she did not mean I have no phone.
Right.
Or computer.
Yeah.
Because we all know our phones are
Yeah.
computers today.
Exactly.
So I mean, I think we get your point.
Good. And so with regard to the other point, she also makes clear throughout the duration of that transcript that she saw that there were officers in her yard. She just didn't know that they were specifically animal control officers until she talked to them. She acknowledges that she saw them when they drove up, and she called her husband to discuss what was happening. And those officers, when they testified at trial, they said they didn't come in any vehicles marked animal control. The vehicles were marked.
I think there was one that was marked animal control.
I don't remember that, Judge Letica, but I will defer to your
We'll
you're
check
reading.
the record.
Okay. Yeah.
We'll make
Thank
sure
you.
that that's correct.
I think this idea, though, that she is unaware is belied by not only the communication with her spouse, but the others whom she's trying to line up as having pre-purchased any of those horses.
I don't disagree, Judge Rick, that she had a lot of communication between when the officers arrived at her home and when she went out to talk to them. I think the quibble here is whether or not she knew they were specifically animal control or some other arm of the government trying to take the horses. So I think it is clear, you're right, Judge Rick, that she believed and she testified to an understanding that somebody was trying to take her horses. She just didn't know it was animal control specifically until she went and talked to the individuals who were outside her home.
So I'm just going to be candid with you. It's hard to buy the argument that she didn't know. I think it cuts both ways and may be subject to interpretation, and therein lies your problem, counsel, because if these facts can be interpreted in that regard, how do you win?
Well, that's why I've raised the ineffective assistance of counsel piece in the alternative. I think the whole of the transcript, which was not given to the jury, makes clear what she meant when she talked about this. And then in addition to that, Your Honor, the other act's evidence, which colors the jury's interpretation of what she was saying.
Assuming trial counsel was ineffective for failing to provide the entire transcript, where is the prejudice, though? How do you get over that hurdle?
The prejudice is twofold, Your Honor. So it's the first, what Judge Letica talked about. It's clear, very clear, I think, from the text of the transcript that the cell phone stuff was not a lie. And so that in turn informs the jury's assessment of everything collectively, right? If she's not lying about the cell phone, and it's clear from the transcript that that's the case, then it seems much more likely that she is telling the truth about whether or not she didn't know animal control specifically was on her property until later. And I think the sum of the transcript, in addition to that, provides enough context that there was no follow-up about this, no clarification. Nobody really probed her when she was asked these questions. It's sort of, to me, it reads as a gotcha. And I think that the transcript itself would have made that clear had the jury had access to it. With regard to the other act's evidence. So the prosecutor elicited 2 strands of statements that were bad acts that didn't have any other purpose at trial. The first was that she had a history of abusing horses, and that wasn't necessary. So all the prosecutor needed to say.
Was it a history of abusing horses, or was it a history of moving when animal control became involved?
I read it as a history of animal abuse, Your Honor. Either way, all we needed to know was that the civil forfeiture hearing was appropriate. And appropriate.
Okay.
That there was a reason to have the civil forfeiture hearing. There wasn't a need to have additional testimony about her abusing animals, especially before all of this took place. So that's what the sheriff testified to. That even before this instance, there was additional allegations that she was someone who was abusing horses, and that in and of itself was bad acts evidence. Similarly, we didn't need to hear about the contracts.
Well, you say that, but at that time, wasn't that one of the other allegations? The one that was directed verdict.
Sure.
Right.
Yes. And it was kind of wrapped up in that, Judge Letica. I think once that's dismissed, say, I agree with you. Once that's dismissed, there still needs to be a limiting instruction to that effect to absolve the taint that comes from that.
Again, nobody asked for it. And didn't this kind of feed into defense counsel's strategy to say they were out to get her? It didn't matter. They were looking for anything.
Yes and no. I mean, that's my take on the situation, is that they were out to get her. I think once he makes that point, he still needs the limiting instruction. And if there are questions about his strategy, that's why we moved for the evidentiary hearing to talk to him about what he was doing and to question him in that regard.
I think it's pretty clear that was a strategy from what he was arguing and his questioning, but
I just would say, Your Honor, that a hearing is necessary to determine that conclusively.
Okay.
Yep. All right. Thank you.
all right, well, you have plenty of time
Thank
for
you.
rebuttal.
Thank you.
Good morning, Your Honor. Nick Johnson, Assistant Attorney General on behalf of the People Appellee. I know the court has well aware of the facts as indicated by the questioning of my brother counsel, so I will get straight to the responsive points. Judge Ledeck, I believe you asked whether the animal or the vehicles on the property during the seizure said animal control. Transcript, day 2 of the trial transcript, page 37, during the questioning of Chief Animal Control Officer Kevin Carr indicated that the one he was driving, prosecution asked, the one you were driving said animal control, and then answer, that's correct. So there is indications in the record, as well as the animal control vehicle and 2 livestock trailers obviously indicates that animal control was there to seize the horses. And Judge Rick, I believe you might have mentioned about the context of her own testimony. And I think I noted this in my brief, 2 days before the seizure, she spoke with her attorney, and her attorney indicated he was going to get the information that animal control was requesting, and specifically told Mrs. Zimmerman not to talk to animal control. And in her trial testimony, she says, my attorney told me not to talk to them. So it's pretty clear that she knew animal control was there by her own testimony, as well as all the other record evidence. So
Do you agree that there is an ineffective assistance of counsel? There is merit to that as it pertains to the jury's inability to see the complete forfeiture transcript. And if you do, how do you get over that?
Sure.
If you don't mind.
yeah, absolutely. So Judge Ledeck, you might even touch on this point as well. There were strategic reasons, and we noticed this in our brief as well, for counsel not doing that. I think, counsel argues that there's context that the jury was missing. Well, I argued that there's context in both ways. I think the jury, the forfeiture transcript shows that she was advised numerous times, don't perjure yourself. These are the consequences if you give false testimony. And so I think there were strategic reasons. This was even brought up. The jury had asked, can we see the transcript? And counsel was apprehensive about not doing that. And so he ultimately agreed to the trial court just writing out what the question, I think it was, the jury was asking what the question was before she had testified about not having a phone. And the trial court and the parties agreed not to submit the entire transcript, but to just simply write out what the question was beforehand. So I think that, and again, there is no jury, there has been no Ginther hearing at this point. So our review is limited to the record. And the record, this court there's a presumption that counsel was effective, that these matters were trial strategy. And based on counsel's handling of whether or not to submit the forfeiture hearing or just tell the jury the question, I think goes to the fact that this was strategy and that was not deficient performance. If this court disagrees and thinks that it is deficient performance, we would argue that there's no prejudice. One, for the reason stated in my brief, which is that only dealt with whether or not she had a cell phone. It didn't deal with the other statement that the prosecution argued was false, which dealt with her knowledge of the animal control. So, and that the entirety of her testimony at the forfeiture hearing about her knowledge of whether animal control was there was submitted to the jury. So I don't think there's any prejudice as a whole. The other point I would make, Judge, and I didn't know this in my brief, but defendant herself testified at trial what she meant. The prosecution asked her at the forfeiture hearing, about the PayPal, and defendant at the perjury trial had said, yes, I was asked about the PayPal, and I specifically said that PayPal, because PayPal uses internet and data, that I meant no phone meant no internet access. So if this court deems that the forfeiture hearing transcript should have been admitted, defendant herself testified what she meant. So that defense was still presented to the jury. So therefore she can't show that there was a reasonable probability that had the forfeiture hearing transcript been admitted, that a different result is reasonably probable. So, and that's her testimony on at the perjury trial about what she meant is on the last day of trial on page 52. So I hope that adequately answers your
Yes,
question,
thank
Judge. Yeah. And that was one of the points I was going to make in my response brief. So I'll move to the last point, which is with respect to the others acts evidence. Judge Ledecky, you noted that there was only testimony about a history of moving animals, and that is correct. As I read the transcript on second day of trial, perjury trial, page 154, 155, the officer is especially, or actually, I think it's Miss Eagleston, who was the prospective buyer that kind of facilitated this, specifically says she has a history of this. And the preceding part of her testimony indicates that this meant moving animals, not any sort of abuse or anything like that. And irrespective of that, this was all part and parcel to the same thing. The reason as to why she was there, why she was at the forfeiture hearing to begin with. And so I've stated in my brief is this is necessary for the jury to understand context and understand a comprehensive understanding of what was going on, why we were there for the perjury trial. So I don't believe it brought up 404B. But other than that, Judge, I don't have anything else to add. I think everything is stated in my brief. So.
Judge Borello, any questions?
Thank you.
Rebuttal?
Yes, Your Honors, just briefly. So the prosecutor has made a lot of hay about this idea that Ms. Zimmerman testified that her lawyer told her not to talk to animal control. And she went and talked to them anyway. That suggests that she, of course, did not know for certain that this was animal control who was coming to seize those horses.
Right, but only after she had talked to Ms. Deems,
Mhm.
Crahan, and said, claim these horses and are you going out? And she said, yeah, I'm going out to talk to them. And in addition to the conversation with the lawyer about not talking to animal control was also some advice that there could potentially be a seizure of the animals.
Mhm.
So that to me is indicative of not, again, our standard of review on these, as you know,
Mhm.
sufficiency of the evidence questions is that we view the evidence in the light most favorable to the prosecution.
Yes,
And
Your Honor.
and we make all inferences in favor of the jury's verdict. It's such a high standard to overcome.
I understand, Judge Ledecky.
Yeah.
And what I would say is that this sort of goes to Judge Rick's prejudice question earlier, is that the sum of the civil forfeiture hearing makes clear the point I'm making. And that's, Yeah.
And he is correct that, there was testimony by
mhm.
Ms. Zimmerman herself, but it wasn't corroborated and clearly it was gone into during closing argument by defense counsel. And then the jury came back with the question, which is, we want the context. And then the court went from, is it the forfeiture hearing that we're talking about to what was read into court? Because I'm not giving the jury anything that was read into court. And at that point, I think counsel's hands were tied to just what was the question that was read before that response was given.
Yes. And as I understand what you're saying, I think you're speaking to the next point I was going to make is that by the time counsel was presented with this choice, the opportunity had passed, right?
That's correct.
Yeah. And so the idea that the civil forfeiture hearing, this statement that we shouldn't give the jury the transcript is not a strategic choice at that point because the proofs had already closed.
And I don't think it was give them the entire transcript. I think it was give them the context in which she made that statement of no phone, no computer.
Okay, sure. So I guess that's the point I'd like to make, though, is that any question about whether the transcript should have gone to the jury was after the close of proofs. I guess kind of building on this, the idea that she was able to testify to this, that no phone, no computer at trial meant, no internet.
The jury heard it.
Yeah, the jury heard it, and I'm not sure if I understood what you just said, Judge Ledecky, so I apologize if I'm rehashing what's already been said, but there was no contemporaneous explanation in the form of the transcript of the civil forfeiture hearing, right? It seems self-serving after the fact without some proof in that.
It was corroborative of what she testified to.
Yes. Okay. Thank you. And the last thing I'll say is that the reason I say that there was testimony about the history of her engaging in the animal neglect is because the officer said that there were several search warrants previously for her for this type of behavior. And that happened on the second day of trial on page 25. That's what I'm referencing when I'm talking about.
That was a pretty open-ended question by the prosecution and he went there. So
Unless there are any other questions.
I hear none and see none.
All right. Thank you, Your Honor.
And
Thank
that
you.
case is submitted. We'll move on to item number 2. And if I mispronounce anyone's name, believe me, Letica has been pronounced in very many different ways. So this is docket, item number 2, docket number 365716, People of the State of Michigan versus Shane Isaac Clendenin. Am I close?
You're correct, Your Honor.
Oh, perfect.
I'm Henry Schneider from the State Appellate Defender Office, and I represent Mr. Shane Clendenin, who's incarcerated.
Okay.
I have some very brief remarks prepared with respect to the virginity and flight instruction issues, but I'm
Mhm.
happy to accept any questions you might have at any time. That being said, I think it's important for the court to remain aware while examining this case that the jury did not fully believe the complaining witness's story. If they had, Mr. Clendenin would have been convicted of 2 additional counts of CSC. And so they clearly harbored doubts about her reliability. And those are thoroughly laid out in my brief, so I'm not going to belabor them for now. But most egregiously, the prosecutor in this case made a pretrial motion to bar inquiry into the complaining witness's sexual history and other sexual partners pretrial, which the trial court judge granted. The prosecutor went on to directly ask the complaining witness when and to whom she lost her virginity. She claimed it was Mr. Clendenin, and trial counsel for Mr. Clendenin did not object at that point. Later, the prosecutor used that testimony during closing arguments to appeal to the jury's sense of sympathy for the complaining witness and to inflame their passions against Mr. Clendenin. Again, trial counsel made no objection during closing arguments. And contrary to the prosecutor's response brief, this testimony was not merely elicited to explain her lack of sexual knowledgeability or inability to testify as to details, and we can tell that because that's not how the prosecutor deployed that testimony during closing arguments. Looking at the quotes in my brief, the prosecutor used that testimony, like I said, to inflame the jury's passions against Mr. Clendenin and to play on the jury's sense of sympathy for the complaining witness. And that distracted the jury from the central issues in Mr. Clendenin's case.
Right, but they weren't so overwhelmed by it that they acquitted of some of the counts, right?
That's correct, Your Honor. And this ultimately was a credibility contest. And as part of the cumulative error argument, we argued that any one of these errors may have tipped the scales unfairly against Mr. Clendenin, but taken in the aggregate, certainly. With respect to the flight instruction issue, there's nothing in the record discussing or testifying as to Mr. Clendenin's state of mind leading up to and including his arrest. The record only reflects that at some point, Ms. Keitzer became aware that a CSC warrant was out for Mr. Clendenin, but the record's absent of Mr. Clendenin's state of mind. What we do know is that at sentencing, OV-19 was not scored at 10. At sentencing, it came out that Mr. Clendenin had been concealing himself in anticipation of a domestic violence warrant, not for the allegations the complaining witness in the CSC case had levied. We also know that no officers who participated in his arrest testified at trial. We know that Mr. Clendenin had contacted authorities 18 months prior, which is, I would argue, the opposite of hiding or eluding or
Right,
trying to
he
escape
said, I'm
justice.
hearing these rumors.
Yes.
Yeah.
That's correct. And We do know that, like I said, Ms. Keitzer's testimony offered no insight into Mr. Clendenin's state of mind at that time. But in some, absent these errors, Mr. Clendenin's trial probably ends very differently. Unless your honors have any questions at this time, I'll have a seat and ask to reserve time for rebuttal.
Hearing none and seeing none. You have plenty of time for rebuttal. Thank you.
Thank you.
Good morning, Your Honors. Paige Petrosky on behalf of the people. I will be relying primarily on my briefing, but there were just a few points that I wanted to touch on. First, the note of the jury not believing MW's story and resulting in the acquittal of 2 of the CSC counts. A review of the record reflects that MW described multiple instances of oral penetration occurring, but she only provided a specific location on the property where the oral penetration occurred for one of those instances. And so it does not take a lot of digging to understand that that was likely, it was not so much an attack of her credibility that resulted in the acquittal of those 2 counts, but more a lack of specificity. But ultimately, it doesn't have an impact on any of these of the issues raised. In terms of the prosecutor using the lack of sexual experience to garner sympathy, first, the prosecutor does not need to make their argument in the most tame of terms necessary, but then also it was very, very clear from the arguments in closing that the prosecutor had elicited this testimony and was using it for the proper purpose of explaining MW's state of mind directly after the first sexual assault. And going to why she wasn't paying attention to stretch marks on her assailants or on the person assaulting her. She had other things on her mind. She was a 13-year-old child. That was the context in which this argument was being made, because they were using that testimony to attack MW's credibility. And it's also corroborative of Ms. Keitzer's recollection of her returning home after the first assault occurred and seeing MW wearing her pants and appearing shaken or more quiet. And so those are the proper purposes that evidence was used for. I'll also note the rape shield protects a victim's prior sexual history, not their lack of prior sexual history. So there was no objection that should have been raised when her lack of prior sexual history was inquired into. And then I'll just note that the scoring of OV-19 isn't really relevant to whether or not the evidence was properly admitted of flight, or whether a jury instruction was or wasn't warranted. Yeah, ultimately it's just irrelevant. And then, excuse me. And then also I just wanted to note that the defendant's state of mind, it is not necessary for the prosecutor to provide evidence of a defendant's state of mind in order to present flight evidence, which I believe was when Smelly overruled People v. Hall, requiring the proof of the fear of apprehension by the defendant. So yeah, that was everything I wanted to touch on, unless there are any other questions. Thank you.
Rebuttal.
Thank you, Your Honors. Just very briefly. First, with respect to the virginity issue, I think it's important that during closing arguments, the prosecutor did not use phrases such as lack of experience or lack of prior partners. She used the term virginity. And that's a loaded term that means different things to different people, and large portions of the population place a lot of value on that. She could have used other terminology and she chose not to. I would argue because she knew that term would play on the jury's sense of sympathy and inflame their passions against Mr. Clendenin. With respect to the flight issue, even if the scoring of the OV doesn't bear on the trial court's determination with respect to the flight instruction, that's the only piece of the record that offers insight into Mr. Clendenin's state of mind at that time. And if you have no other questions at this time, I'll have a seat.
All right. Thank you both. This matter is submitted. We'll move on to item number 3, docket number 370499, People of the State of Michigan versus Rogelio Nazario Reyna. And we have Miss Walsh by Zoom, I believe.
Good morning, Your Honors.
Or Miss Walsh.
Susan Walsh on behalf of Rogelio Reyna.
All right. You may proceed.
Thank you. I'm aware that the panel has thoroughly reviewed this case. I think that the issues are straightforward and laid out in detail in our briefs. I would just note for the record that the prosecutor argued that the evidence of the other acts were reliable in part because of Mr. Reyna's guilty plea for the January 20th case. But the guilty pleas weren't taken till after this trial. So I think that needs to be pointed out to the court and emphasized. So that wasn't true at the time of the trial. So unless the court has any other questions, I would rest on my brief in this matter.
Okay. Hearing none and seeing none, thank you. And we'll go ahead and hear from the other side.
Thank you. Paige Petrosky on behalf of the people. I also will primarily rely on my briefing. I will note that the mistake in when the guilty plea actually occurred, that is fully my error. So I just want to make that very clear. And that should not be considered, but our argument still stands regardless of that point. And unless there are questions, I will rely on the briefing.
I hear none and I see none.
I'm sorry, what was that?
I think we're good.
Oh.
And Ms. Walsh, do you have rebuttal to that point?
No, mistakes happen, and I totally understand.
Appreciate counsel's candor. Okay. Thank you
Yes.
so much. Thank you both for appearing and for the briefing, and this matter will be submitted.
Thank you.
All right, we're on to item number 4, docket number 369-418, People of the State of Michigan versus Raymond Christopher Barrios.
May it please the court. My name is Mary Owens and I'm here on behalf of the defendant, Mr. Barrios. You have to excuse me, I'm a little bit under the weather, so I might not be as sharp in answering your questions as I would ordinarily.
Okay.
But I really have a very brief argument to present today. And that is about the sufficiency of the evidence to sustain his convictions, Mr. Barrios' convictions, because the testimony and the evidence in this case was so controverted. It was so ambiguous that we believe it's not even sufficient to sustain the conviction. And I understand what the standard of review is, that you review the evidence in the light most favorable to the prosecution. But it has to be, I believe it should be the evidence as a whole, not just say one person who said, I saw him shoot Mr. Espinoza. But you look at all those other eyewitnesses who said, no, it wasn't him. They couldn't identify him in the courtroom. Other witnesses who misidentified or picked someone else out of the photo lineups. Other witnesses who didn't see who it was at all. When you consider that evidence as a whole, I think you have to say that it's really not sufficient to say it's beyond a reasonable doubt.
Well, the photo array that you're speaking of, counsel, as I understand it, some of those didn't include the defendant's picture.
That's true. That's true. There were several photo lineups, but there were at least one other that did have his picture in it and he wasn't picked out. So that's the essence of our argument, Your Honor, pertaining to the sufficiency, and that would encompass both of the premeditated murder and the assault with intent to commit murder charges.
But do you agree, counsel, that to some extent you're asking us to place greater weight on the credibility of some witnesses than others? And obviously, as an error correcting court, that's not our function. So if there are, the jury picked whom they believed and didn't were not convinced by these other witnesses and their testimony.
Well, I disagree, Your Honor, that I'm asking you to substitute your own findings for that of the jury. I mean, you are an error, the court is an error correcting court, I agree. But that involves when you're dealing with a question of sufficiency that you look at all the evidence and you look at it on the record. So I'm not really saying for the court is not in a position of judging anyone's credibility at this point because you have never seen the witnesses testify, but you are in a position to evaluate the record as a whole. And that's why I cited that one case that said if a reviewing court is in equipoise as to whether someone is guilty and or innocent, then you have to come down on the side of acquittal because by definition, that is not beyond a reasonable doubt. So that is the essence of my argument. And I think that there's really not much else that needs to be said.
Thank you.
Thank you.
Good morning, Your Honors. Amanda Ingram of the Kent County Prosecutor's Office for the Plaintiff Appellee of the People of the State of Michigan. I am prepared to rest on my brief as I covered the standard of review and that is necessary for sufficiency and the other issue in this case. Unless you have questions, I will leave it at that.
I see none and I hear none.
Okay, thank you.
Thank you.
Ms. Owens, I don't think that there's anything to rebut from that. So, all right, thank you both. The matter is submitted. We'll move on to item number 5, which is a consolidated case. 371-522 and 371-814, Linda Baker versus Ottawa County. You may proceed.
Please the court, Donald Visser on behalf of the appellants in this particular matter, as well as I guess the cross appellees in the consolidated cross appeal. Does the court wish, I'd like to reserve 5 minutes for rebuttal, but does the court wish for me to address the cross appeal now or after brother counsel has addressed that cross appeal?
Have you talked about it?
We have not.
You have not. Okay. Well, since he would technically have rebuttal as a cross appellant, why don't we go ahead with you and then he can rebut and he can do the cross appeal and then.
All right.
You can, we'll figure it out.
Thank you, Your Honor. In the original appeal in this matter, the issue there is the awarding of interest. And what was awarded, which was essentially in this case, a disgorgement of what the county treasurer had, in this case, who was a foreclosing governmental unit, what had received, and it was just a small percentage of what would otherwise be available under the statute. There's uniquely not a lot, despite the fact that we've had a long history of condemnation actions in this state. There's not a lot of history as far as case law is concerned regarding the interest rate. And that's because in most instances, the evaluations occur under the Uniform Condemnation Procedures Act, which sets forth the interest rates and so forth. But in this particular instance, the only situation or only case that I was able to find that really addressed it was the Miller's Brothers versus Department of Natural Resources, which set out that citing in a petition of the State Highway Commissioner that from the time of the taking until the complaint is filed, the proper rate is under MCL 438.31. And then afterwards, it's under the revised Judicature Act after the complaint has been filed. And that, of course, wasn't awarded here. What was awarded here is reference to some rate that it was perceived by the trial court that the FGU actually received from the investment of these funds. And of course, what that doesn't, that's not the only advantage or the benefit that the FGU received. The FGU also received the benefit of not having to bond under MCL 211.87A at SEC, which is a very expensive and a time-consuming process and so forth. That is one of the huge reasons why the county treasurers got into this business and so forth, is because they could build up a reserve and avoid bonding. Yet that wasn't considered by the trial court as one of the benefits. If you're looking at disgorgement, you say, okay, let's look at what you saved on that as well and compel you to disgorge that. We don't think there's any precedent in Michigan law that disgorgement is the relevant measuring stick. Rather, it is interest itself. And we would therefore ask the court to reverse on that and designate to the trial court whether it's to follow Miller Brothers decision or whether it's to follow the Uniform Condemnation Procedures Act, which ties in with the legal rate of interest set by the Internal Revenue Service for delinquencies. We set forth in our brief a number of other alternatives. I think those alternatives give you at least an idea how inadequate the relief is that the trial court gave in this instance. Turning to the second appeal that we have, which is a post-judgment appeal, that is having to do with the award of interest. I'm sorry, award of attorney fees.
Mhm.
And I'm just going to do, I think I'm going to make it relatively simple here. The trial court did recognize the Pergo factors. The problem is the trial court blended those all in instead of following the Pergo methodology, said that's all taken into, all of those things are taken into consideration in the underlying rate. And that's not what Pergo requires. And Pergo requires to, first of all, evaluate the hours and the rate, and then make the adjustments up or down from
Right.
that, as opposed to just blending.
Oh, we're quite familiar with.
You probably have
Pergo
quite a few
standard.
of those.
Oh, yes, we do.
The one case is an unpublished decision by we, I think is you versus Radiswitz. It's a September 5, 2024 decision in docket number 365887. And I think it addresses there what happened here, exactly the type of thing where it's kind of all merged. And the court defined where the error occurred. Therefore, the manner by which the trial court determined the award amount constituted an abuse of discretion. So that's what I'm really looking. I think it's real hard to say, well, this particular element or that particular element is the abuse of discretion because it's not enunciated and set out by the trial court. And therefore, it causes the inability for this court to do a review to determine whether an abuse of discretion of the factors occurred. So the core thing is that every trial court must go through that step and or those steps of the evaluation, and it is an abuse of discretion not to follow those steps. I don't know that there's much else that I have addressed on the appeals. I would indicate that I do not believe that this court has jurisdiction as to the cross appeal, but I can address that on rebuttal. Thank you.
May it please the court, Ted Seitz on behalf of Ottawa County on these appeals. I think one of the key pieces In fact, I think the key piece for this appeal, and it's a little unusual because this is a case where certainly the briefing is, I'll say it's old. Things have moved on since the briefs in this case were filed, since the issues were here. And so frankly,
We know you just filed something today, right?
we did, Your Honor, and I understand I just substituted into the case, and I understand I find the case as the briefs are, but certainly these authorities are from our Supreme Court. And I think the key issue now is, frankly, this case is subject to 78T, 211, 78T, and the exclusive remedy process that was retroactively put into place by the Michigan Supreme Court in the Schaefer case, as well as Hathan.
Mhm.
And there's been some subsequent decisions by this court, one unpublished, that I think
I was on the panel.
I know, Your Honor, I know you're on the main one as well,
Yeah.
the project case all along,
Mhm.
that I think provides what should happen with this appeal.
Okay.
So, I mean, clearly, the retroactive 78T process would apply to the plaintiff's claimants, potential claimants case here. They are in the, pre-2020 period of foreclosures and sale. Certainly, surplus proceeds, remaining proceeds were generated from those sales. But, our courts have said, including the Supreme Court, along with In re Muskegon, the published decision from the Court of Appeals, that 78T is the exclusive remedy, and that's the path that needs to be followed, not, these other causes of action, right? They're outside of 78T, which is what this case originated with. It started before the statute was even amended to add 78T. So it had claims like 1983, it had claims like conversion. All of those, our court has said, that's not the remedy anymore. The remedy is, even going back retroactively, 78T. So the pathway here should be, and frankly, it's an unpublished decision, Your Honor, Proctor, on the last one on remand, but it does have throughout kind of the analysis of how those would apply, and the Proctor plaintiffs would be the same type of situation that these plaintiffs here are in as well. I think they are all, I know they are, all pre-2020 plaintiffs. And in that case, in the unpublished decision, the court has the pathway of, we're going to remand these back to the trial court to consider 78T claims. We understand that the time period for submitting the 78T retroactive claims have passed from what the Supreme Court said, but it's, a fair and absolutely equitable thing. The Court of Appeals in Proctor, that section says, well, you can count tolling while their case has been sitting in the Court of
Yes.
Appeals. So the instructions here should be remand this back to the trial court, go through the 78T process, and that's exclusive remedy. There's no case that allows interest or attorney's fees as part of the 78T process. It's not allowed. So to have this court rule, not send it back and award attorney's fees and interest here would be kind of an outlier in a parallel action.
It's not, interest is not in the statute, right?
Right. Yeah, in 78T, Your Honor, it's certainly.
Correct.
Yeah, so there's no talk of interest on remaining proceeds. And certainly, 78T has been challenged constitutionality wise. It's been challenged to the United States Supreme Court in some cert petitions. Those were all denied in January of this year. The rehearing on those cert petitions was denied. It was yesterday by the United States Supreme Court. So 78T constitutional and is the path forward for these claimants here. That's my rebuttal.
And
Yeah.
what about on the attorney's fees?
Yeah, the attorney's fees would be the same thing, Your Honor. It should go back to the trial court, Ottawa County, and they can evaluate these in a 78T type of claim process. And if they want to seek attorney's fees down there, they certainly can, and see what the judge does. And if he awards it or doesn't award it, I'm sure there may be some sort of appeal from that. But I mean, 78T is the exclusive remedy. for these claims, and no attorney's fees are mentioned at all for plaintiffs or claimants as part of that process.
All right. Mr. Visser, you have plenty of time for rebuttal.
Thank you, Your Honor. First of all, I think the court,
And you probably received it today, right? The supplemental.
I did, and I really don't think it has much to do with the issues involved, but your honors can grill me to any contrary beliefs that you might have as to why I feel that way. But I think the core issue here is there is no jurisdiction to challenge this claim. This cross claim was filed in the second case, which is a post-judgment appeal, post-judgment issue over attorney fees. So they tried to reach back, and Sermon versus Sermon at 277 Mishap, 287 and 2007 cases, a party cannot wait until the entry of a subsequent final order to untimely appeal an earlier final order. And that's really what's happening here is they're trying to reach back in that subsequent appeal of the attorney fees to challenge something that they cannot do. So therefore, that's a jurisdictional issue, and I don't think the court needs to even get to the merits. Secondly, what complicates the FGU's opinion here is there's two aspects of this order that was entered. Obviously, there is an underlying offer of judgment that was entered against the FGU itself, and then we went to trial or went to hearing on the interest in attorney fee issues against the county, but there's no basis, no matter what happened in the change of the law or whatever, after that fact, there's no basis for interrupting or impairing the judgment based upon the offer of judgment that was accepted. The FGU does not provide this court with any authority by which it can go back and look at final judgments that were entered by the court and say, because there's a subsequent change in the law, that we get to undo that. I think that position is also complicated by the invited error doctrine in this case, because we went through the trial and the FGU conceded that based upon Schaefer versus Kent County, which was then a published Court of Appeals decision, that the law of the state of Michigan was binding on the trial court, that in fact taking had occurred and Raffaelli was retroactive. Now, it took another 2 years before the Michigan Supreme Court addressed affirmed that, and it thereby triggered the provisions of 78T. But as one federal judge intimated out of the Eastern District, we're not too sure that the statute just didn't create another cause of action as opposed to extinguishing any. And part of that goes into looking at, and that's not been developed yet very well through Court of Appeals decisions, but the implications of 78L, because that was also modified in 2020 as part of the provisions changes on December 22 of 2020. And what 78L has a much greater exclusivity provision to it, which before the modifications in 2020 said simply that if somebody did not get notice, they had to bring a claim for damages in the Court of Claims. So the circuit courts didn't have any jurisdiction over it. It had to be brought in the Court of Claims. The modifications in 2020 to 78L said now, oh no, we're going to make it an exclusive, including, it's going to include state constitutional and federal constitutional. Although there's still some question whether, based upon Williams versus Reed out of the United States Supreme Court, whether Michigan can by statute preempt what Congress has authorized under 1983. But Schaefer versus Kent County at the Supreme Court level, they addressed that and said 78L is prospective, 78T is retroactive, thereby removing the question of whether constitutional claims in pre-Raffaele, basically in pre-2020 cases, are exclusive. So you got the exclusivity clause of 78T only, which says claims for remaining proceeds have to be followed under 78T. That's the exclusive way to get remaining proceeds. It's not broad and expansive as 78L is, which includes constitutional claims for surplus proceeds. And so then we have this, I don't know what adjective I should use for it, the ruling of the Michigan Supreme Court in Hathon versus State in March of 2025. I really don't know how binding that is. Other cases, it's certainly binding in Hathon, but it's really not developed as it should be in accordance with, to be precedential in accordance with Article 6, Section 6 of the Michigan Constitution. But it says in a footnote that the interest and the 5% basically wait for a different day. Well, what I think Brother Counsel here is trying to argue today, well, it's all taken care of. Well, that clearly shows that the Michigan Supreme Court wasn't saying it's all eradicated. And that comes because of basically how you have to look at 78L. It wasn't eradicated, and that constitutional issue has not yet been addressed. So to say that 78T, whatever Proctor says and so forth, it really didn't dive down into that issue, but it certainly can't be that it precludes everything in pre-Raffaele cases, because Hathon itself in a footnote acknowledges it. I don't know how applicable Hathon is. Obviously, we've got to give it some meaning, but whether it's applicable in other cases, I don't know, because there's not a developed factual scenario and reasoning with the order. So I think that the issue here really is jurisdictional. I can talk forever about the substantive part of the issue and the constitutional aspects of the statute, or at least my beliefs on it. But I think the defining issue here.
I don't think we've seen every permutation yet, but we've seen a lot of
You
them.
may see a new one in the next argument, but.
Yes,
so
maybe,
Maybe.
yes.
I don't know if the court has any questions of me.
I see none and I hear none.
Thank
So,
you.
thank you both. And this matter is submitted. With that, we'll move on to item number 6, which is a series of consolidated cases. 376-481, 376-482, 376-653, 376-655, 376-656. Are you FLE? Yeah. Would you mind? It does help us.
In Lansing Court, with my toe on the edge of the table, and it felt wet in my face.
Oh, no.
I guess there's more than one way to do it.
Hopefully you were not injured.
Oh, little, other than my.
I think we have immunity. Don't we have immunity? Go ahead. Don't mean to make light of it, Mr. Visser.
Good morning, Your Honors. Assistant Attorney General Matt Hodges appearing on behalf of the State Treasurer. as FGU. And with me at council table is Assistant Attorney General Brian McLaughlin. This is a little bit, I hesitated coming up here because we are not actually endorsed on the first case here, but it's
Okay, they're all together.
sure.
We're not giving you 30 minutes on each.
No, and I don't intend to
individual
try to
case.
use.
This is it.
Understood.
So, yes,
Just wanted to
but
be
have
clear.
you, and I see here there is a cross appeal?
Correct.
Okay, so did you talk about how you're going to do that or?
If not discussed, do you want to follow the same format as we just?
Okay, all right,
Thank you.
then please proceed.
Thank you. I would like to reserve as much time as I can because I do think that we're going to get into a number of issues and our primary issue here is pretty straightforward. I know that there's a lot of briefing the court had to review for this. There is a cross appeal. There are a number of issues within each of those cases, but I think I can simplify it somewhat. Judge Rick, you had when you were on the bench in Clinton County, you heard some of these tax foreclosure cases. They have since changed in procedure because of this post-judgment seeking surplus proceeds. But it is one case with potentially hundreds of properties in it.
Right.
And each of those properties could have multiple former owners. So that's kind of why they're all coming up from the same circuit court case.
I wondered whether you might just address, I know at one point there was a concern that there was going to be a groundswell. I mean, did that ever materialize? Because I think you wanted some guidance from our court back in October.
Correct, yes. And
So tell me what happened since then, if you don't mind.
yeah, no, absolutely. So different circuit courts have kind of gone different ways on the primary issue here. And just to identify that, it's the statute of limitations and which years are still ripe, if you will, to
Are viable.
yes, viable to compensable to make this, to use this new process. And different courts have gone different ways. Some circuit courts have agreed that the statute of limitations is, as we have argued, and denied some of those older claims. Some, including, and let me back up, some of the bigger circuits that have multiple judges have, like this one, have issued decisions, and other judges in the same circuit with similar years have decided to hold off and wait to see what's going to happen prudently, I think. But so we have a divergence there. But we also have 6 claims of appeal we filed yesterday from another circuit court on the same issues from underlying cases. Statute of limitations is the primary issue. I believe we'll probably be filing, or the other side will be filing in other circuits, probably 2, 3, 4 more at least. I think there will be more, unfortunately. We do need this guidance still. I think it's an important issue and some of,
Publication.
I think it would be helpful. Yes. Either way,
And how-
because
If I may, I'm
Yes.
sorry. How far back, like what's the oldest case,
That-
if you will,
that
that
we've handled and
where this argument is being, bandied about
sure.
the proper statute of limitations? Because if I remember correctly, we're looking at what, 2014 here, but anything before that?
Top of my head, I don't think so. I think that's
Okay.
kind of where maybe there was so these are, I don't know if you remember this piece, but it's a 13 case. That's when it's filed. It would be a 14 foreclosure and a 14 sale. So there's kind of but that would be 2010 taxes. So there are a lot of numbers at play here. I think there might be a 13 case out there. I think these are 14.
Just more my curiosity,
sure.
again, based upon the filing that was previously made about,
Yeah,
is there going to be an eruption? It's.
we've seen some of it.
Okay.
We've seen some of
Thank
it.
you.
So the core issue here, we think, is the statute of limitations question. And we do think that the Schaefer Court did a really good job and spent a lot of time discussing kind of the retroactive application of this statute. They first said, yes, Raffaelli is retroactive. People that were foreclosed on before our decision can seek compensation, but it wasn't open-ended. Then they said, those all get funneled through 78T. There isn't a separate action anymore. There's not an inverse condemnation. But we recognize this statute didn't exist when these foreclosures happened. So what they essentially did was import the timelines from what your cause of action would have been had you filed when it accrued. And as long as you still had it pending, you could funnel it through 78T. But if you didn't have anything pending and you were outside that statute of limitations, which would have applied, that door is closed. 78T is not open to you. That's basically our argument. That's essentially what our argument is. And I believe that's exactly what Schaefer went to lengths to explain to us, you know, both for counties and for the state being the FGU, what those timelines were. And these simply do not satisfy those timelines.
I appreciate we have a cross appeal, but if I'm hearing you correctly, that's outcome determinative then.
It would be. I would love to get an answer to all these open questions. This does provide a number of those nuanced and unique things that I think you referenced in the prior case. I don't know that this is the case to decide them if we're correct. So I would, if you have questions, I'd be happy to.
It would just be dicta, right?
I believe it would be, you know, well, there is an interesting question. So I'm actually asking that you reverse or vacate and remand it to the court for entry of an order granting our motion for summary disposition.
Mhm.
It was an issue that would have applied to any claim made in this case based on when the events happened, and that would have been the same for all the properties and all the potential claimants in that case. But that would kind of bring into the fold whether the cross appeal issue about the use of motion practice at this stage. So I suppose that could be in the mix if that's the route the court went. Okay, I'll reserve the remainder of my time. Thank you.
Please, please the court, Donald Visser on behalf of the claimants in this particular instance. I'd like to maybe start off by answering the groundswell or eruption question. And there are a number of pending cases for claims that arose prior to 2014. But theoretically, it would only go back to 2000 because that's when the new practice started. So in one of the trial courts, somebody asked me, well, could it go back to 1900? And the issue might be, well, theoretically, but no, in this case, it cannot, because that's when Michigan changed the General Property Tax Act to go from the old foreclosure method to the current one that's been declared to be unconstitutional. That grouping of potential claimants is further reduced by the fact that the window is now closed. The window under 78T begins with needing to file a notice of intention by last March 31 and a motion by October 1 of 2025. So the grouping of people that have made claims is well defined. I am aware, I think, of a spattering of claims that go back as far as 2010. So I don't know of any claims that would go back to those earlier years or approach 2000, but that hopefully answers, gives you a practical viewpoint of what's happening out there. It's our belief that the state's desire in this instance to interpret Schaefer actually begins by requiring us to engage in a bit of intellectual dishonesty, because you have the first rule of statutory interpretation, which says you may not, courts may not, parties may not go to interpreting a statute through case law or whatever, if the statute is clear. And the statute of limitations is very clear. It begins on the day of accrual. So what is the date of accrual? We set that forth. Livingston County Circuit Court also very clearly said the accrual is the first day that you can set forth a complaint setting forth all of the elements of your claim. The uniqueness of this statute is it sets forth that first day for pre-Raffaelli when the Michigan Supreme Court declares that Raffaelli is retroactive, which was July 29 of 2024. At no time prior to that date could anyone make a 78T claim if they were in that category prior to July 18 of 2020 as set forth in the statute. So I don't know that we can go on and start interpreting what Schaefer says or not, but I'm going to discuss that because I think, at least as I see it, the comments that my brother counsel is trying to make here really puts the language of Schaefer into a dicta category. And I say that because there was no intersection of 78T and the statute of limitations at play in Schaefer. In fact, there were no 78T claims involved with Schaefer. There were only constitutional claims, both by Hathon and by Schaefer himself. And why was that? Because 78T didn't exist at the time when they filed their claims. So when we start looking at the language, and I've noted in reply to one of the briefs that when the state wanted to explain what Schaefer said about the claim, they put in bracketed phrase 78T claim. That's not in the language, but they felt it necessary to put that in there, but that shifts what the court was talking about. What was the court talking about? It was talking about the constitutional claims. And I draw that from looking at the comments made by the court in his claim, as well as the concurrence that was filed by Justice Zara. And it talks about the claims, and talks about the fact that let me see if I can find my notes. I apologize. Yes, it would be deeply concerning for a statute to prohibit an individual from exercising his First Amendment or due process rights for a material length of time conditioned on a discretionary act unrelated to the substance of the right. Similarly, it is highly alarming that the legislature prohibited constitutional claims for surplus proceeds until this court accepted an appeal and issued a specific holding. Over 3 years have passed since 2020 PA 256 was enacted, and for over 3 years, the statute has attempted to bar relief for individuals whose constitutional rights were violated. Then he goes on. If this court did not grant leave to consider Schaefer, individuals around the state may have been denied a remedy for violations of basic constitutional rights for which they were entitled to relief. At the very least, the attempt to close off relief in PA 256, pending discretionary action from this court, risks serious uncertainty, disruption, and expenditure of finite public resources in adjudication of constitutional claims. The main body says doesn't discuss the issue a great deal, but I think Justice Zara's concurring opinion talks about that discussion that occurred. The main body of the opinion says, therefore, if filed within a reasonable time of the day's decision, claims that arose prior to the date of PA 256 enactment, but expired between the date of enactment and the date of today's decision must proceed while still respecting the applicable statutes of limitations. That cannot be discussing anything other than constitutional claims, because it says claims that arose prior to the date. There were no claims that arose prior to the date under the statute prior to July 29. Those claims did not exist. What was the court concerned about? Those constitutional claims such as Hathon and Schaefer had, which were put on hold by 78L for 4 years, 3.5+ years. They were put on hold. They were buried. You could not proceed with them because the statute said so until the Michigan Supreme Court said 78L is prospective. It's not going to be applied. So now you have what are the claims? That's why I say it's dicta, because they weren't addressing 78T claims that had never been presented. Now, in recognition of the court limiting itself to the issues in front of it, if they had intended to address it, and if it was necessary, we would say it's not dicta, but it wasn't necessary because there were no 78T claims involved. Our office wrote an amicus in the Hathon decision. The Schaefer was presented as a calendar case. Hathon was argued on oral argument whether leave ought to be granted. Justice Zara had requested that at least the 5% the constitutional aspects be addressed. But the parties themselves had basically argued about the aspects of class action, because Hathon was a class action on the Court of Claims, and all of the things that were necessary to the class action. Our amicus said, whoa, watch it. They're not addressing the Constitution. There's a whole bunch of constitutional issues involving here. And if you look at just at, for instance, year 2020, the foreclosure occurred effective March 31 of 2020. Hathon was decided on July 17 of 2020. I'm sorry, Raffaele, I apologize. July 17 of 2020. The sales throughout the state occurred in August and September of 2020. Public Act 256 and 255 was December 22 of 2020. What did it require? It required the people who lost their houses in September and August of 2020 to have filed a notice of intention by July 1 of 2020, which was before both the act had been, before the act had been passed, before the sales had occurred, and even before Raffaele. So there were obviously some unconstitutional issues relative to 78T's application and so forth. Those did not get addressed. We urged the court to give it a full calendar status so that those constitutional issues could be addressed. They were not. So I feel more comfortable when I read the decision saying they were addressing the only issues that were in front of that is the constitutional claims of both Hathon and Schaefer, and therefore those are the claims that they're talking about. You won't find anything that talks where the court says the 78T claims. They're talking about the claims. And as you can tell by Justice Zara's concurrence, he makes it very clear it's the constitutional claims that are being addressed. And then I would say, if my brother counsel is correct, that somehow it impacts 78T, that would have to fall within the definition of dicta because it was not necessary for the case to be decided. And in fact, it was in the end was not decided. So we would also, obviously, we have a cross appeal on the issue of the procedure. And we believe that all gets wrapped up into the recent case of this court in Montcalm versus Rivera describing the function of the FGU. 78T7 describes the response, the administrative response, the information that the FGU is required to provide to the court. 78.9 then addresses how the court is going to handle that information. And it has the conspicuous phrase in it that the FGU may attend. There is nothing in the 78T7 which says besides all this information, whether the claim is timely or whether there are other issues for the FGU to insert if they want to and so forth. That's not there. And if we're going to look at a strict statutory statute, which has been described when they wanted to be so described as being concise and precise statute for determining rights. Well, if that's the case, let's confine the statute to what it says, what information the FGU is to reply. And I think now the binding effect of Montcalm versus Rivera is very clear that the that the FGU cannot go past that particular information, introduce additional issues. If you look at the statute as a remedial statute, you arrive at the same result. You don't look at the statute as how, I almost sometimes get the feeling that the FGUs look at this often as a case of heads they win and tails my clients lose. Everything is construed supposedly to keep people from what Raffaelli and Tyler at the federal level have said is their property. And instead, we're going to try to separate you from your property by all of these additional defenses. That's not remedial. So I would say a remedial reading of the statute, it's exactly what it says, and there's nothing more for the FGUs to do. I think it was an abuse to allow it the procedure. You know, we still got to get to the, I guess, to the merits, but the procedure, we've got a post-judgment order that's being appealed. All of a sudden, we're going to go way back. Do we get discovery and everything else? I just don't know how the earlier portions of Chapter 2 can actually be applicable to a post-judgment motion, which is defined by the statute, supposed to be very limited, except I guess when some parties, not the claimants, want to broaden it. So that's, I have some real problems there. I've also briefed interest because we were deprived of interest. And interest in this context is a bit different than the last case when I was here, because this is in a pre-Raffaelli, this is a statutory remedy as opposed to a constitutional remedy. The prior case was constitutional. And the statute does not provide for interest, but the Revised Judicature Act does. And it provides, and so you look at what type of an order is this? Does it look like a return of property? Well, there's nothing in the statute that talks about a return of property. There may be something ethereal in the background that if it weren't a statutory remedy, that it was a return of property, but it's not a return of property. But I particularly raised it because of the footnote of the Michigan Supreme Court in Hathon versus State, and that it says that those issues are preserved. I could not, and that's the problem with an order like that that's not well developed. I could not tell whether that meant we have to go through the 78T process, and if the trial court awards it, it's therefore moot, or it means that it's outside of that and therefore preserved for a constitutional challenge post 78T. I think either reading is probably permissible, or it can be developed. So I wanted to make sure it got before the court. Obviously, something's going to take off from this panel's decision on that as to whether it is to be included within the discussion because it's a constitutional remedy, or it's not. I find it interesting that the state would make the dichotomy saying this is not, you're not entitled to interest because it's a statutory remedy, but then try to say for purposes of the inserted statute of limitations argument, oh, it really is a constitutional violation. That's what we're tying hanging our hat on. So those seem to be diametrically inconsistent positions to say that, yeah, it's constitutional, but really it's not, it's statutory. So finally, I would say if the legislature had wanted this to be limited, it would have been very easy to say so. And I don't think it's up to this court or any court to substitute wisdom that the legislature may have omitted. They use language which says for sales prior to July 18, 2020, this is what you do. They didn't say for sales prior to July 18, 2020, and not barred by the statute of limitations, or they could have said, but not before July 18 of 2015. They didn't say that. They just categorically put a bracket on it and says, if you meet that, I therefore submit to the court that the statute is clear, it's unambiguous, and that's the standard that ought to be used. I don't know if the court has any questions.
And then I see none.
Thank you for indulging me.
Thank you.
Thank you.
Just a couple of points here, and then if the court has any questions, I'd be happy to try to answer those. On the prior groundswell question, I guess I hadn't really contemplated the idea that somebody would argue it could go back to 2000. That would be even worse than we thought it might have been before. I think at that point, we were probably the foreclosing governmental unit, the state treasurer in 25, 30, 35 counties for a number of years, and that's dwindled. We're down to 5, but that's more than I had anticipated hearing. The interest question, I want to go to that and make sure we touch on it. This is the place to raise it. The Supreme Court told us this is a claim following a tax foreclosure for relief from an alleged taking. Everything related to that needs to be brought in this case. So it was appropriately brought if that's the argument you have. It's just not provided for in the statute. It's simply not there. If some court holds otherwise and finds that it has to be paid, then so be it. But certainly our client is not in a position to pay out a bunch of money when it's not in the statute. They're not authorized to pay it. The Montcalm decision, the Rivera decision, I'm glad that came up. It's been used in this context in several circuit courts that we've been involved in, and attributed the meaning that we just can't participate, basically, cannot respond or provide arguments that would inform the court about things that would disqualify people from receiving these payments. I don't think that's what the decision says, but it certainly shouldn't say that. That's a concern I have. And I think that ties directly into whether or not there's an ability to have motion practice here and raise discrete legal questions for the court. And frankly, when we filed a motion for summary disposition here, it was an issue that would, as I said before, apply to everyone in that case, but it also provided a briefing opportunity for the other side to develop that issue and respond to it. If it was simply raised in our response to their motion, that's the end of it. It's been raised for the first time. There's no development of that issue. I think it is important enough, this issue is, and there could be others in the future, that this needs to be an avenue. Using Montcalm to say that that's not appropriate is really closes an important door that the circuit court should be deciding how to maintain their dockets and what they need to hear from people. The idea that the Schaefer and Hathan decisions are dicta for pages and pages and pages, we would disagree with that. There's clearly an outline there that had a purpose and was important in that case. They were concerned with taking an existing case under a takings theory and saying this new statutory remedy, I want to be clear, it's not a cause of action. It's not creating a new claim. It is a remedy. It is a procedural remedy for claims arising in this very context. They had to say that they weren't leaving people without a remedy, that thought they had one, that had exercised their rights, had pending cases that were timely. So they needed to go through the statute and say, well, if we do that, how do we need to apply it? And what would that mean for these folks from prior to December 2020 to make sure they don't get cut off? And so they looked at 78L and they looked at the prior statute of limitations for claims against the state, compared them and said, we're not going to shorten that. We can't shorten what they would have had before. So they did have to reach that issue. It's certainly not dicta. The idea, just one last point, 2 points, sorry. The accrual of a claim turns on the events, the underlying events that give rise to a claim. It's not when a new remedy is created by statute. I don't think I need to develop that anymore. There is a question, an interesting thing here, and caused a little bit of the paper volume that you have. There's a question about whether the prior orders in this case that touched on substantive legal issues like the statute of limitations that we separately briefed, whether we needed to file a claim of appeal from that interim order or waive the right to appeal the substance of that order, or if we could have waited for the final order on the claimant's motion and tried to wrap that up. It is a post-judgment phase of the case, so it's a little bit unique. We did not want to waive that. And really the substance of the court's analysis on this issue was in the interim order. So we thought it was important to protect that. I think it probably would have been cleaner if we were confident that if we had waited until the final order on the proceeds, we could have wrapped that all in. I don't know if that's even something that can be cleanly sorted out here, but I think there's conflicting case law on that, or at least practice. So with that, unless the court has any questions, I would ask that you reverse and or vacate and remand and direct the court to enter an order granting our motion for summary disposition based on the statute of limitations. Thank you.
Thank you both. Thank you both for the excellent briefing. And with that, the case is submitted. Right, before we begin our 11 o'clock call, we're just going to take a short recess. All right. All right, well, good morning and welcome to the 11 o'clock portion of our docket. As you know, the math does not work for the 10 o'clock. I have been in your shoes, so actually this is kind of timely. So we're going to just dive right in, and where I have further instructions, I'll just go ahead and do it at that time. We're going to call item number 7, docket number 371-165, 12-5 Capital LLC versus MG Marine LLC.
Morning, Your Honors. Drew Broadus for the appellant. So this is our appeal by leave granted from denial of our motion to set aside a default judgment. And counsel is probably gonna have a lot to say based on the brief about how I jumped into deep waters and there's a lot going on here that we don't know about. And that may be true, but for this record, for the default judgment, it cannot stand. And the reason is very simple. The complaint was not for some certain. And once that's established, if the trial court had correctly recognized that, then you get in the issue of notice had to be given if it's not for some certain. Court rule in the case law are clear on that. And without notice, we don't even reach the meritorious defense. And that's the Brooks Williamson case, published decision of this court. So, I mean, I think this particular judgment really can be distilled. It's just that simple. I had trouble finding law about what is a some certain, but I think it's instructive. The federal courts have described it pretty consistently the same way. And this is not in my brief. I'm going to cite KPS Associates versus Design by FMC 318 F 3rd 1, page 19 from the First Circuit, 2003. Claims not a some certain unless there is no doubt as to the amount to which the plaintiff is entitled as a result of the defendant's default. Term some certain in this context contemplates a situation where once liability has been established, there could be no dispute as to the amount due, such as actions on a judgment, enforcement of a prior judgment, negotiable instruments, situations like that, where there's no need to resort to extrinsic proof. So here we have, I think the best indication that's not a some certain is they had to amend the judgment and ask for $350,000 less than the initial default judgment.
Which they say is a Scrivener's error.
It could be, but that really defies the concept of it being certain, the certainty aspect of a some certain. I mean, it's right there in the phrase. And when you look at the complaint itself, I mean, we have
It
many
asked for
different,
25,000.
that's really the gist of the relief. There's other references to numbers, some bigger, some much smaller. In paragraph 14, they talk about 3.7 or almost 3.8 million, which is much larger than what they ended up asking for. There's references, none. And the interesting thing is none of these really add up to the 2.6
Right.
that
No,
we ended up with.
the
And that's,
math does not work.
the math doesn't work. And I don't think that you're supposed to have to do math. I think it's supposed to be right there in the request for relief. And in the brief, they've referenced the STAO form in defense of the idea that you can enter a default and default judgment simultaneously. But again, that form, the title of the form, I don't know that it's in the record, but the court can take judicial notice of the fact that in the title, it says some certain in parentheses, that's what it's for. So when they point out, yeah, every time that form is used, you're doing a default and default judgment without the intervening notice. But again, only if it's a sum certain.
Right.
We don't have that here. So notice had to be given. And it wasn't. And the Brooks Morrison case talks a great deal about the fact that when the notice isn't given, it becomes a due process issue to then enter a judgment. And it's not the only case it talks about. There's another case I thought was very interesting that wasn't in the brief. And this is Bullington versus Corbell, 293 Mishap 549, 2011, at page 561. It talks about a lot of the ideas that were later explored in more detail in Brooks Williamson, but there's two quotes in there. If the pleadings do not state a specific amount demanded, the party seeking default judgment has to notify the defaulted party of the request for the judgment. And then it goes on, failure to give notice required by 2.603 invalidates the judgment. Again, there's no discussion there of meritorious defenses. And the trial court kind of jumped right into the meritorious defenses. Plaintiff has in their brief, wants to talk a great deal about the meritorious defenses. A lot of that discussion is not in the record or not properly part of the record. And the reason why is because this is an interlocutory appeal. What happened afterwards isn't part of this court's review of the judgment appealed from. And IOP 7210 parentheses A, subpart 1 talks about the fact that the record relates to the decision appealed
Is
from.
limited to,
Right. It's sort of like a summary disposition. And if you went on summary disposition, leave was granted and went on to some other party, you can't use that without a motion. I suppose they could orally ask for it today if they wanted to expand the record to bring these things in. And I'll point out the Ivankovich deposition, 12/19/24, that's 7 months after the default judgment. His default is almost a year after the default judgment against my client that's on appeal today. Again, not part of this record. If they were to make the argument that somehow that has to be reviewed, if they were to ask the court to expand the record, first of all, none of that deals with whether it's a sum certain and whether we got notice. It's undisputed. We didn't get notice after the complaint. But Ivankovich is not IMG. Separate corporations and their owners are respected. There's been no veil piercing argument. So whatever he said that they make much fuss about in the brief, it doesn't necessarily blow back on IMG. Maybe they can make that record on remand. I don't know. But it doesn't undermine IMG's position here. And again, the default's totally irrelevant. Whatever is admitted by that default only is admitted as to him individually. So that's really the highlights. Or there's any questions? Otherwise, I'd like to have a little time for rebuttal.
you have plenty of time for rebuttal.
Oh, thank you.
Morning, Your Honors. Gage Salvius on behalf of the appellees at 12-5 Capital. So counsel primarily addressed in his oral argument his position that the complaint is not for a sum certain. And I would direct your attention to the court rules, which, as Judge Hamlin properly determined when he conducted this analysis, the complaint does contain a sum certain. The complaint alleges the value of the collateral that defendants stole or misdirected from Leelanau County is worth at a minimum $895,000. And then the complaint further alleges that IMG violated MCL section 600.2919A, which entitles 12-5 to treble damages. And if you look at the court rule,
So you just said at a minimum, that indicates that might be a bottom line, but it might not be the damages, right?
correct, Your Honor, but we did not request more than that minimum. So the amount pled in the complaint provides a minimum. And if you look at MCR 2.603B2, section 4 this rule is regarding when a written request can be entered by the clerk without notice to the defendant. It says it may be entered by the clerk if the damages amount requested is not greater than the amount stated in the complaint. Now, that rule does not say anything about in a specific portion of the complaint. It doesn't require anything in the wherefore clause specifically. It just says that the damage amount requested not be greater in the default judgment than the amount stated in the complaint. That's what happened here. We stated a minimum amount that damages were certain for.
Except you also said or more than $25,000, right? The damage, you didn't put that amount in the bottom.
In the wherefore clause,
Yes.
yeah, in the wherefore clause, it says we were seeking a judgment in excess of $25,000, but that doesn't negate the fact that we have pled definitively a minimum sum certain in the complaint that can reasonably be made certain by computation, which is also in the.
Well, then you would think if that's what you were going for, it would be in the prayer for relief, right? That amount, that exact amount.
Well, Your Honor, I don't believe that that's the requirement of the court rule. I believe that the requirement is that the damages amount requested is not greater than the amount stated in the complaint.
Okay.
And our request was not greater than the amount stated in the complaint. Yeah, paragraph 30 alleges that the minimum value of the collateral that was stolen was $895,000. And how we calculate the total damages then is trebling that amount. And again, MCR 2.6032A says the plaintiff's claim against the defendant is for a sum certain or for a sum that can by computation be made certain. And multiplying 895,000 times 3 for treble damages, it can reasonably be made certain by computation. So there were no procedural irregularities with the request for the default judgment. We used form MCOA because under the court rules where the sum can be reasonably made certain and the defendant has not appeared in the action, the relief requested is not different in kind from or greater in amount than that stated in the pleadings where we stated in the complaint that minimum amount that can be trebled. Judge Hamlin properly conducted this entire analysis, determined that the complaint contains an amount that can be a sum certain because it can by computation be made certain. The last item I want to address on the notice then is because the court rules that we've referenced here, specifically MCR 2.603B1A and 2.603B2, deal with a sum certain as we have alleged in the complaint. No notice was required until after the judgment was entered, and that notice was provided. So there were no procedural irregularities. Proper notice was provided timely in when it was required under the court rules. And that deals with the notice requirement. Separately, the procedural irregularities that they claim with the default process only go to the element of good cause. It does not address at all the fact that they must show good cause and a meritorious defense. I can rely primarily on our pleadings on the meritorious defense, but Judge Hamlin was familiar with this case. He understood that the statement of facts that was submitted by Mr. Ivankovich was incredibly contradictory. It contained facts that were inconsistent with testimony he had heard previously in similar matters. And if you look at their statement of facts, that alone is sufficient to establish personal jurisdiction over IMG, the admissions that they make in their verified statement of facts, including that they invested $2.8 million in a Michigan company, that they made loans to a Michigan company to complete work on boats that were being manufactured in Michigan, that they have possession of boat hulls that were taken from Michigan, that were stolen from my client, that they shipped those boat hulls to Dubai. All of these admissions are made in their verified statement of facts. And Judge Hammond properly determined that under MCL 600-715, which requires only the transaction of any business within the state or the doing or causing of any act to be done, which result in a tort, that we've properly established jurisdiction over IMG Marine. Council noted that we included in our brief the fact that what we have asserted and alleged and they have admitted in their verified statement of facts has also ultimately proven to be true through discovery. That is the case. It's not necessary for the confirmation of Judge Hamlin's decision that they have not identified a meritorious defense, but we believe it to be worth noting that they have now admitted everything that we alleged regarding their transactions in Michigan, their contacts with Michigan, their business dealings in Michigan. So if the court has any further questions, I'm happy to address those. Otherwise, I'll rest on our briefing.
Rebuttal, Mr. Boss.
ING hasn't admitted anything. So we have been out of the case for 7 months. Mr. Ivankovich was testifying in his own capacity as a defendant in his own right at that point. But the important thing here is counsel suggested that even if the notice had to be given and it wasn't, that's only the good cause element. But if you had to give notice, you don't reach the meritorious defense. Brooks Williamson explains that in some detail. But on that topic, I would point out the trial court relied a great deal on a record from another case that IMG wasn't a party to. For one, that's the first issue that I think is a problem if we reach the meritorious defense. But two, there's no case that says you have to win a motion for summary disposition to establish a meritorious defense. It just has to indicate facts that would support a motion for summary disposition on certain grounds. And the level of analysis that trial court applied here when he dove right into that without dealing with the notice issues, and then seemed to expect that we were able to completely, refute the jurisdictional assertion at that stage. It's not what it requires. Especially at that point when there's been no discovery. And then the other issues, that wasn't the only defense. I mean, he had other explanations, and it dealt with the fact that there are multiple corporations here, and there's an argument that IMG didn't necessarily make these investments that they're talking about. There's multiple Aquaform entities. Could have been him in his own capacity. There's a number of people referenced in that affidavit. I wish the affidavit was clear, but the fact that you can read it a couple different ways doesn't undermine the meritorious defense. But again, Williamson Brooks, if you're persuaded that it's not a some certain, then they had to give the notice, and the lack of notice means it has to be set aside. And a final point in the some certain, the strongest indication is not a some certain here. The $25,000 figure appears 3 times in the complaint. And the fact that they had to amend the judgment, it's that easy to compute. Why wasn't it right the first time? With that, unless there's any questions.
No question. Do you have an issue with they said a minimum amount of damages at this? And then they just multiplied the minimum amount by 3?
I mean, that's what they're saying, but I mean, you get down to where they talk about trebling, they talk about trebling an amount in excess of 25,000. So I don't know. It's readily apparent. I mean, you got to presuppose, you know, there's conversion and then there's conversion. Not all conversion is trebled too. And they throw out, you know, the number 3,770,000, I'm sorry. A different, much larger number appears in paragraph 14. There's different numbers in paragraphs 24, 25. I don't know how much we're expected to read into their allegations to put it all together to say, oh, that's the figure. And the analogy they're drawing is to an SEO form. It's theoretically that simple.
It would be much clearer if they actually said in their prayer for relief. Here it is, and it's that amount.
Great.
Okay. I think we get the point. So thank you both. This matter is submitted. We'll move on to item number 8, 370-431. Justin Doomstra versus Michigan Land and Outing Company. If I pronounce that incorrectly, please correct me, counsel.
Good morning, Your Honors. Drew Broadus for the plaintiffs' appellants. This quiet title action, we've assigned error to a couple of rulings of the circuit court. I think the easiest way to deal with this case is at the summary disposition phase as to both. We have the Hallbergs and we have the Westerwheels. Slightly different record as to the Westerwheels because their claim was disposed of after a bench trial. But the Hallbergs went on summary disposition. But really the error in both of these, the testimony does not establish the hostility element as to either of these parties. And what we had described, and this goes back to the extent I understand the trial court's ruling on this point, he's looking back to the 50s and 60s and people's recollections of everyone kind of having this utopian, like we're all sharing the beach and everyone's friends and no one has any issue with where you are. We all agree that you have a right to be here. And that does not meet the adverse element for adverse possession when it's permissive and everyone's sort of just getting along. There's no evidence of hostility. And it's an odd case because I don't think there's a dispute over what people testified to. And I don't think there's a dispute as to the law, but I think where our assignments of error come in is where the trial judge applied that testimony to the elements of adverse possession. And we disagree with that in a couple of ways. And hostility is the main one. And that's kind of the overarching issue for both the Westerwheels and the Hallbergs is the absence of hostility. There's also a problem with taking and I'm sorry, tacking. Didn't mean to confuse because we're already in land use of land and takings are not a part of this. There's no government. So the adverse possession argument as to the Hallbergs was decided on summary disposition. And again, the burden here, clear and convincing as to each element. We talked about in our brief the fact there was a consent judgment involving the Hallbergs, which again, consent, you know, by its very nature, it means it's not hostile. In that judgment itself, it talks about their being given permission from Macquarie to make certain uses of the beach. Now, the way the judge in the trial court got around that, he said, well, it was already a done deal by 1978, that the tacking, the period from 1963 to 78. And again, the testimony, I don't think on that point is supported it. I'm not even sure we had people that were even there. I think it's more of, you know, here's our general recollection of the vibe out there on the beach, for lack of a better term. And then there's a tacking issue with the Hallbergs because the judge said, well, you know, we're looking at this long succession of ownership rights and well, the boat dock and the boat and the dock were a part of some of those transactions. And we talked about on page 34, we're talking about this in reference to the Westerwheels tacking argument, but this was part of the judge's reasoning as to Hallberg as well. And that's erroneous because it's got to be in the written instrument. You can't just look externally and say, well, there's a deck there, there's a dock there. So that's a reflection of the privity to get to the tacking. So, and again, the Hallbergs also talk a great deal about the fact that they weren't initially named as a party. None of that, that's all water in the bridge. They're not claiming they were prejudiced in any way. They got in, they made their arguments. They had a full and fair opportunity to litigate it. I'm not sure why they make such a fuss about that. They talk about a scheme to steal the beach, which obviously wasn't part of the trial court's finding. It's not really relevant to any issue in the case. And then the Wester wheel is a little bit more complicated, but again, the same issue with the testimony kind of just being, you know, painting a picture that doesn't line up with hostility. The Wester wheel's tacking argument is different because they seem to be relying on this third way of tacking where you have a parole transfer and the property owner is well acquainted. That's only to thus far exists in the context of prescriptive easements. I've talked about the fact in my brief, those are not the same. There's good reason not to necessarily recognize this concept in the adverse possession realm.
But wasn't Mr. Westerwheel, I mean, he was a child when the tacking happened back in the early 1960s. And I think you mentioned there not being evidence or scant evidence. I mean, he was there and also submitted family photographs, if I'm remembering correctly, that he was in with his grandparents, with his parents. How do you,
Well, again,
should we be treating that information? Because it seems to me that,
well, for one, it's contrary to hostility. To much of his testimony was contrary to hostility. That particular testimony may support, you know, the fact that this was, you know, handed down and certain rights went with that, but
well, tacking is different from hostility.
right, but you gotta have hostility too. You gotta have both. You gotta have.
I understand, but
Yeah.
I guess my question is, so do you, are you in agreement then that as it pertains to the Westerwheel property, that we can check the box as to
No,
tagging?
I don't think you can. I don't think it's.
Okay, tell me why.
Because what it's come down to in the briefing is they've talked about, they've used again, it's just like with the Hallbergs. The trial court referenced the dock and boats being a part of these transactions, and to get that privity, to establish that privity for the tacking, it's got to be in an instrument. Unless they can appeal to this third way, which no court has allowed in this context. And that's really the gist of it, is that you don't have the right instrument to show that this beach was part of it. You got to have some other way, and then that's what they've kind of come down to. And that's not been recognized other than prescriptive easements, which are very different. And then the Westerwells also prevailed on this acquiescence theory, which is a little bit odd and maybe requires some explanation, but first of all, that should have failed because of the lack of a common boundary. And that's the step one for any acquiescence argument. There's fairly strict requirements. It's got to be known, definite, certain boundary. Here we're separated by an alley and a boulevard with surveys in support of that. And you got to show that my client agreed to the new boundary. I don't know that they got there. The weird thing about this is after the bench trial, the Westerwheels asked for leave to amend to make this theory. We actually argued, no, it's too late to add it. The judge sort of seemed to take that under consideration for a little while and then eventually realized, no, it actually was in the complaint all along. And I point this out not because we're not making a procedural argument to it, but I'm just pointing out it was a sort of an afterthought at the bench trial. It was kind of a gotcha argument. Like it just goes towards the fact that I don't know how you can really make these fairly strict proofs to establish acquiescence when it wasn't really a priority for them at the bench trial. So I think that finding was also erroneous.
Thank you. Any other questions?
Thank you.
You have plenty of time for rebuttal.
May it please the court, Daniel Olson on behalf of Lester and Claudia Hallberg. Just want to make one statement, and that is in regards to opposing counsel's comment on tacking. And he says it has to be via the deed, and that's not the case at all. If you look at page 11 of our brief, there's actually three exceptions to that. And one is parole statements made at the time of conveyance. And that's exactly what the trial judge found in this instance. This is where I had affidavit after affidavit where everyone said, yes, when I acquired this property, it came with a dock that was installed in the water and sometimes even with a boat. And the judge said that was sufficient for purposes of tacking. And then also in regards to, I thought it was interesting, the judge said, you know, he said there was two ways to satisfy the 15 years. 63 to 78, 79. That would be the Drews, Hummels, and Moore. Then he said the Coopers all by themselves, which were 79 to 1994. And in fact, there's a third one in regards to Dimestras, and that is the Hallbergs. Hallbergs have owned that property since 2000. So they would have 15 years in regards to any claims that were made by Mr. Dimestra. Well, unless the court has any questions, that's all I have.
I know none that I see none.
Thank you.
Good afternoon, Your Honors. Joel Barr on behalf of the Westerwheels. And indeed, with the tacking situation, as to the Hallbergs, the court focused on the second option, but as to the Westerwheels, focused on the third option, which is through property owners that are well acquainted and the successors in interest had visited and used the property for many years prior to the title transfer, and the predecessor undoubtedly intended their rights in the property to transfer. And here we had the unrebutted testimony of Roger Westerwheel, who's actually in the courtroom today, so interested in this, and I'm thankful for that. But in these situations, how do you go back 70 years and prove something that happened? And lo and behold, the Westerwheels had all of these photos, and we actually had to consolidate them down to about 120 that are part of the record. And Roger meticulously walked through each of those photographs, and it was emotional, telling stories of when he was a kid, about his parents and about his grandparents. And as Judge Springstead said in his opinion, there's no one more well acquainted with this area than Roger Westerwheel. And that's a hugely important point with the court's determination of the credibility and the use and occupancy of the Westerwheel Beach area. It was unrebutted. The Dimestras and the other plaintiffs never presented any evidence. It was unequivocal and established that since 1952, the Westerwheels have enjoyed riparian rights to this property, which were adverse and hostile to those that had a better claim of title under the riparian rights that would otherwise exist under Michigan law. As Judge Springstead found, they met every single element of adverse possession. And the plaintiff appellant's view of the hostility argument is much more narrower than what Michigan courts require. The testimony of Roger Westerwheel, again, showed that their use of the Westerwheel family all the way from 1952 was hostile to the claim of the true property owner. Now, in this situation, Judge Springstead, based on Michigan law, appropriately found that adverse possession was established as of 1967. Well, then the plaintiff appellants argue, well, there's no common boundary. Of course, there's a common boundary, as Judge Springstead found in 1967 down in that beach area based upon the riparian rights that the Dimestras own. And then since 1967, under the theory of acquiescence, the boundary was established. And Judge Springstead did a really good thing here. After the trial was over, he asked if he could go visit the property and get a visual of it. I really appreciate a trial judge that cares so much about reviewing the facts and the evidence and actually taking the time to go see it. And it was fascinating to just, again, we're not taking proofs of the record on that point, but just sitting back on the Westerwheel property, observing the judge taking it all in. And that shone through as an opinion.
One of the issues that I don't know has been focused on is exclusivity. And as I'm looking at the photographs, it appears that, and the trial court judge would have been aware that people went to their space. I mean, there are uniquely carved out what appear to be beaches that, the various litigants made that are attached to their dock. But can you enlighten me? I mean,
absolutely. There are boundaries. And those are established in the record. Those are established in the final opinion, that to the north, the boundary between the Dimestras and the Westerwheels, there's actually a wooden post in the ground.
mhm.
And the Dimestras' predecessors in interest had built a barn on their area of the beach that runs parallel just inside of that wooden post. So that's one boundary. Boundary on the other side is the roadway. Boundary on the other side is the lake. And then a boundary with the Hallbergs, again, is a wooden post in the ground that Mr. Hallberg testified saying, we agreed, that's the boundary. That's what they treated as the Westerwheel Beach. Here's the Hallberg Beach, the McRae Beach is over here, the Dimester Beach is over here, and up and down the line. And so exclusivity was never really an issue at the trial because all of those 120 photographs showed the Westerwheel family using and enjoying it for over 70 years. And it's something that the Westerwheels desire to pass on down to their children and their grandchildren. And I think that's why Roger was so emotional in his testimony of recognizing when I was a little kid, and here I am on the beach in this photograph enjoying it, I want the same for my grandkids as well. And so I really appreciate the time that Judge Springstead invested in this case and reviewing all of the evidence. And again, the plaintiffs never called anybody at trial. They never presented any history. It was only the testimony of Roger Westerwheel and only the testimony of Les Hallberg that was presented to the trial court. Thank you for your time. Thank you.
Rebuttal, Mr. Broadus.
My client is also here in the courtroom, Justin Dimestra, and it's a big deal to him too. I don't think it's disputed that it's a big deal to all involved. But again, you know, I'm back to where I was in the beginning, which is the hostility. I mean, we've heard emotional testimony, but it's to some extent that's emotional because he's reminiscing about a time when everyone out there was getting along and there wasn't a lot of regard to who was where. And we heard some discussion about exclusivity. That's not one of our assignments of error on appeal. And it's a separate element. And I don't think the hostility, that's really the argument as to both is the hostility element. Did this testimony establish that their use, even if it went back all the way, was hostile? And there's still some issues with tacking. The Westerwheels acknowledged they're relying on that third method, which is still yet to be applied to an adverse possession case. And to some extent, the Hallbergs alluded to it too, and they mentioned a parole transfer, and pretty clear they're talking about the second method, but to the extent they want to use this third way as well, I mean, there's not a case, and I don't know that this is the one that anyone's really explained why we would make that leap to take that concept from prescriptive easements and apply it here. And that's all I have. Thanks.
Thank you. And that matter will be submitted. We'll move on to item number 9. Docket number 375198, Sarah Sagun Yango versus Ikuchua Augustine Okachi. If I mispronounce those names, please feel free to correct me. You can come up. And just so you know, our rules are, since you are the only party that's endorsed, you have 15 minutes. You can use it whatever way you like. But I do note that we have read your brief, so we know all of the issues that you've raised. And I think, I can't remember the exact number, but at least, I think maybe 10 issues. So if you want to focus on the ones that you think entitle you to relief, please go ahead.
Thank you, Your Honor. Good morning, Your Honors. My name is Sarah Sunanyongo, plaintiff pro se. This appeal presents a few discrete verifiable legal errors. They're not requests to reweigh the facts and not invitations to second guess the trial court's discretion, but errors confirmed by the face of the record. First, the trial court acknowledged that relocation would increase my income by 633%, which would have gone from $14,167 to $110,000 annually with benefits. Yet it also found that increase in income would not improve my children's quality of life. Brown versus Loverman holds as a matter of law that a substantial income increase satisfies factor A, which is the quality of life of the minor children. And I do believe that the court applied the wrong standard in that regard. Second, the trial court admitted on the record that it had independently researched my expert witness using the the state bar directory, and Canon 3A4 of the Michigan Code of Judicial Conduct prohibits that. Third, the state's own CPS investigator said on the record that the fact that I had voluntarily entered into a treatment facility to address my mental health concerns was a bonus and a positive. But the court kind of held that, the trial court held that as a negative. And so I believe that for any one of these errors, reversal is required. The cumulative picture also demands reassignment on remand. I respectfully request that this court reverse the April 8, 2025 opinion and order and remand for a new hearing before a different judge with instructions to apply MCL 722.31 for faithfully to the record. Under MCL 722.314A, the central question is whether the proposed move has the capacity to improve the quality of life of the minor children. So the record here is unambiguous. My 2024 income was $14,167. I had two confirmed job offers, one for $100,000 and the second for $110,000 from Streamline Security. And the HR manager from Streamline Security, her testimony is on the record, and I referenced that throughout my brief. So that was not in speculation, it was corroborated by the record. The trial court acknowledged all of this, and it still found that that income increase would not improve my children's quality of life. To the best of my knowledge, no Michigan decision has ever held that a 633% income increase would be neutralized by the availability of services that the family would have access to at a fraction of the income. The trial court also stated that I had only sought employment in Houston, and that's not accurate. I had been in the job market for quite a bit of time, and I so happened to find employment in Houston, and I did have a support system in Houston that was willing to help me to settle down and also help my children to settle down. The court also relied on testimony from adverse witnesses, which I had filed a motion in limine to exclude their testimony because of the fact that prior to that hearing, there had been conflict, and I knew that their testimony was basically a retaliation. But the trial court did not acknowledge that or use that to weigh their credibility, and that weighed adversely on the outcome of the hearing, and also it's actually reflected throughout the trial court's opinion and order. And so I would like this honorable court to look at all of those factors and consider reversing and remanding to a different judge to weigh these, look at these questions independently and make a decision that is in line with the statutes. If there's any question at this time, I'm happy to answer them. Otherwise, that's what I have, and I thank you for your patience.
Okay. All right. I think you did as good a job as some of the lawyers that we have up here in front of us. So we appreciate you coming. And what happens next is that we will prepare an opinion and it will be sent out to you when we have a decision.
Thank you, Honor. Have a great day.
You as well. All right, that matter is submitted. And we'll move on to our last case of the day, item number 10-369-306, Richard Howard versus Joseph Winston.
May it please the court. Good afternoon.
Yes, good afternoon.
Edgar Roy appearing from the Traverse City Law Firm of Kuhn Rogers on behalf of the appellant, Mr. Winston, defendant from below. I'd like to reserve 5 minutes for rebuttal. If all goes well, I may not need it.
So far, we've been doing well today on that. People have not been taking all of their time, and I find it a very rare case where all of the time is necessary, but go ahead.
Well, I was here when you made the comments at the beginning about being well prepared, so appreciate that. Challenging for me today for preparation was I was not trial counsel. I came into the case 2/3 the way in and kind of a subordinate role. The other thing that was challenging to me was reviewing the transcript from the June 2023 hearing on the motion for summary disposition. So I kind of like to focus on that because that ruling really touches on the first six issues on appeal.
Okay.
The trial court's ruling under C10 in favor of the Howards was, from my position, conclusory, and he failed to make numerous findings which are important to the issues on appeal. The transcript that is dispositive possibly of many of the issues was only 6 pages long. Why is that important for us today? It was important because of the trial judge's failure to address in that 6 pages a number of issues. The first issue was that he did not recognize, and I believe it was argued, but I wasn't there, that the offer from the Howards had a 2-day expiration. January 11th was the date of the offer, said it has to be accepted by 2 days later. He never made any findings. He never made any findings on the Howard's failure to sign Mr. Winston's counteroffer inserting the land contract nomenclature. And the Howards, of course, did not sign the counteroffer. The next issue that I believe is important that the court failed below to address was that the Howards waited, I believe, 10 days after receiving Mr. Winston's offer until the Howards obtained their fair market appraisal of the property and the house inspection. Only at that point did they deliver the $20,000 earnest money. And that was when they delivered the earnest money only 6 business days before the agreed closing of February 4th. Another important factual issue the trial judge failed to address was what the purchaser's realtor proffered on the date of closing, the agreed date of February 4th. She proposed an extension of the agreement until February 25th. What I did not realize until my preparation was not only did she ask for an extension of February 25th, she also said in this addendum that the Howards reserved the right to obtain inspections for the septic and for the hazardous inspection that was going on. That was actually when she made that addendum, Ms. McLean. Those inspections were required under the strict terms of the purchase agreement to be completed by January 31st. Again, the judge did not, in my opinion, explore and certainly didn't rule on these issues. Next, the judge struck the 5-day contingency that Mr. Winston wanted to look at and negotiate the land contract. Lastly, the judge failed to apply the FOSSI elements, of which there are 8, for determining whether land contract terms are dedicated, expressly stated. He did not address all 8. He just said in very general terms, I find there to be enough of the terms for land contract, which really was amount, interest, and amortization. He also never imposed on the Howards the good faith and fair dealing requirement that he, the judge, imposed on Mr. Winston. Why is that important? The case of Kircher versus Boyne USA reflects that the court does not allow for imposing as a claim a breach of good faith and fair dealing, where there are express terms in an agreement. You follow the express terms of the agreement. Turning now to what I think is maybe the more substantive argument, has to do with equitable accounting.
Before we go there, can I ask a question that I just want to make sure I understand, because I thought you indicated your client had requested the land contract, the purchasers had requested the addendum with the land contract. Can you flesh that out for
Yes.
me?
Purchase agreement came with a provision that the purchasers wanted seller financing. Provided amount of, call it the gross payment, gross amount of the land contract, the interest rate and the amortization. The purchasers did not provide a land contract. My client, the appellant, in responding to that offer, added a phrase to the effect, the essence was the land contract was to be negotiated and there was 5 days to do that.
Okay. So it was not at his request. He was trying to give meaning to the offer that they had made where they were asking for seller financing.
Correct.
And with respect to your client, he was unaware in the moment that the existing liens would have prevented him from providing a land contract. And with respect to, is it an appropriate conclusion then to draw that had the purchasers initially not requested seller financing, the deal would have gone through?
Thought about that question. I think if it had been a cash offer in that amount, then it could have proceeded directly. I'll call it a cash to close or mortgage to close.
Right.
That would have been a seamless track to complete the transaction. So I think that's a long way of saying yes on these facts.
Okay. Thank you.
The last issue I'll move through quickly has to do with the equitable accounting. The essence of that argument is that under Michigan law, the court is obligated in granting specific performance to try to put the parties, both parties, in the same or similar position as they would have been had the transaction closed on February 4th. I believe, fallacious determination by the trial judge, he gave the Howards credit for all of the rental income with some offsets. All the while, Mr. Winston is paying two mortgages, interest of $59,000, I think $998. And why is that important? The judge in subsequent rulings after June of 2023 said, I don't know if he used the word double dipping, but that the Howards would be obligated to pay interest once there was a closing on the land contract over the 2-year life of the land contract. That was a wrongful assumption for this reason. The transaction closed on the land contract. An hour later, Howards pay off the land contract. So Mr. Winston paid the interest to his mortgagor. The Howards got credit for this 16-month window without having to pay even interest on the land contract. The judge, in practical terms, could have said, don't know if it was argued, but he could have said, the Howards do have to pay the interest rate over the 16-month period and gave them a credit on the land contract moving forward. So what has happened here is, through opposing counsel's, I think, very astute approach, his clients got the benefit of the rents without having to pay contract interest had the parties closed on February 4th. And it's about $60,000. So that issue was not addressed, so far as I know, in the trial transcript to show that the judge balanced the equities of the parties under and granting specific performance. The Howards got a windfall of the interest that they would otherwise have had to pay for that 16-month period because they were they closed on land contract, cash to close right behind it. So the trial judge's assumption, Mr. Winston would garner that interest over the payment or life of the land contract was simply false.
I understand your point.
All right. So I think with that,
You have more than 5 minutes for rebuttal.
Good afternoon, Your Honors. I am Greg Light. I am the counsel for the plaintiffs, the Howards. With regard to the argument that Mr. Roy made, I understand he wasn't there, I was. And so part of the reason that I think it's important for the court to understand some of these issues he's saying were not addressed by the trial court, they weren't raised in the motion for summary disposition. The 2-day time limit on the offer, I don't even believe that was raised in the appeal briefs, or at least I didn't see it. The failure to sign the counteroffer, there was an admission in the answer to the complaint that the parties had entered into a binding agreement. And so there was no argument, either in no affirmative defense in the answer, there was no argument made in the motion for summary disposition that failure to sign the counteroffer box was made that there be no binding agreement. Earnest money, same thing. No argument raised in the motion for summary disposition related to the earnest money.
Yeah, that's paragraph 14. Is that paragraph
I believe that's
14?
correct.
Yeah, so yeah, just kind of looking back at this, it seems that that would have been the best way to undo all of this, right? Kick back the earnest money, be done.
Well, let me answer that, Your Honor, if I may.
Doesn't matter for this appeal, but it's a burning question in my mind.
Well, sure, but here is what I will say to that. And I think if we go to the Faso v. Meyer case, which is a case that they heavily rely upon, and Mr. Roy says was not addressed, that case actually supports the plaintiff's claim in this case. The trial court described the agreement in that case as a form purchase agreement that basically was an agreement to enter into a land contract. There were payment terms, but that was about the extent of the specifics of the sales contract. That's exactly what we have here. And the seller in that case said, we're entitled to summary disposition. You can't specifically enforce that agreement. And the Faso court said, that's not correct. You can have an agreement to enter into a subsequent agreement. And all of those 8 elements were present in that agreement, and they're all present here. Mr. Roy wants to limit that analysis to just the addendum, which had the payment terms, the $100,000 down payment, the amortization period, all of that. But the agreement is the agreement. It's the purchase agreement and that addendum.
And that purchase agreement includes language regarding seller financing.
It sure does. It absolutely does. So if we go through those 8 elements, it's got the parties, got the property description. There is a provision for marketable title. That's paragraph 13 of the agreement. There's a fixed contract price, the amount and timing of installment payments. That was what was in the addendum. The interest rate also in the addendum. Adjustment of taxes and assessments, that's in paragraph 7 of the purchase agreement, and the right of possession in the vendee, that's in paragraph 9.
So the seller should have either rejected in the first instance.
Yes.
Or someone, I don't know who it is, not Mr. Roy, he wasn't part of the deal. Somebody should have said something like contingent upon the seller being able to provide a land contract.
Well, and I want to be very clear about that. The answer to that partially is yes. There could have been other language added to the agreement, but I also want to be very clear. It's not as if the seller could not do a land contract on these terms.
Well, they had to come up with some.
He would have had to come up with
significant-
some money.
Yeah.
Absolutely.
And the 100,000 doesn't cover 150.
That's correct. But those are all things that he knew at the time that that purchase agreement was signed. And it is a fundamental principle of Michigan contract law that parties are deemed to understand the terms of the agreements that they sign. And that includes the mortgages that he signed, which predated this purchase agreement. He didn't like the deal he made. It was going to be more difficult for him to close it, but it doesn't make the agreement unenforceable. And that is the basis for him to, so all the rest of this, right? Well, there weren't terms about insurance or the escrow agent in the land contract. All of those other things are just window dressing. What he really decided was this is not a deal that he wanted to do, but he can't get out of it. I mean, that's the nature of it. And so, and you know, we've set forth in our papers the answers to some of these other arguments that have been made to the extent the court has questions about any of those. I'm happy to answer questions about that. But the other thing I would say is that at the end of the day, the arguments about what the substance of this land contract, recall that with their closing argument, the defendant submitted their proposed land contract. And it had all of these terms, the protections and all of the things that the defendant is saying, these are things I need to be able to effectuate this land contract. And the plaintiff said, okay. They signed, or they agreed to every provision with one exception, and that was the allocation of transfer taxes, which by statute is allocated to the seller. But other than that, every provision in that proposed land contract, the plaintiff said, we agree. And that's the land contract that was incorporated into the judgment. So there's no basis for saying there wasn't a meeting of the minds. In fact, there was. And that is the basis of the land contract, and that's closed, and the land contract's been paid off, as Mr. Roy alluded to.
And so can you address his last point about the interest?
Absolutely. So the job of the trial court is to try to put the parties in as near a position as they can be in. What the plaintiffs agreed to was a couple of things with respect to interest. They agreed that they would pay no more than 2 years of interest, but they also would have had the ability, had the agreement been closed at the time that it was supposed to be closed, to pay it off immediately. They were deprived of that opportunity because of the actions of the defendant. And in fact, as Mr. Roy alluded, they closed on the payoff of the land contract immediately after the land contract was signed. And so they would have had that opportunity. Because they were deprived of that opportunity, that is interest that they shouldn't have to pay. And there is case law that is cited in our papers, and I will.
If it's in your brief.
Yep, it's the Giannetti case, but it says that the trial court should err on the side of overcompensating the plaintiff because it's the defendant's actions that caused the issue.
Okay.
If there are any other questions, I'm happy to answer. Thank you.
Hear none and I see none.
Well, I guess we took Judge Elsenheimer up on his offer. He said a couple of times, just appeal me if you don't like it, which
Yeah, he
is
did.
maybe common to you folks, but the bench, but not to me. So I think
You'd be surprised how many times I actually see that. That's why we have appellate courts, is usually what they say.
just quickly,
Go ahead.
one of the issues that is very problematic to me has to do with Ms. McLean on February 4th submitting addendum, we'll just call it to extend the closing to February 25th. And to allow buyers to continue to be able to rely upon inspection reports, which candidly, if they didn't like, they would not have to close. So my sense is there's a little game playing here, but Judge Elsenheimer did not seem to think he needed to address why and for what purpose was Ms. McLean's addendum in place. I believe that it does deserve, and I hope Court of Appeals will address that in some fashion. One thing Mr. Light and I absolutely agree upon, I believe, I'm safe in saying it, there are a lot of realtor missteps in this whole transaction. I think opposing counsel makes a good argument about saying that the Howards were deprived of an opportunity of paying off the land contract, therefore they would not have had to pay interest. And I accept that at face value. But it begs the question of during this 16-month period where Mr. Winston is paying about 60 grand in interest carrying costs, the Howards received all the financial benefits of rental and no interest costs for that. That just seems unfair and incongruous because the judge could have, with the amount involved, he could have netted that out. It's about 60 on both sides. So to that end, I believe he did make a mistake and we're looking for this court's, I believe, de novo review of the equitable issue here. And I appreciate the court's time. And
thank you both for coming, and the matter is submitted. And this concludes our day one case call.